Hi, I'm attorney Jonathan Simon, and as part of our family law practice, we're unfortunately faced with circumstances that warrant us to file motions for contempt on behalf of our clients. When you file a motion for contempt, essentially you're asking the court to not only enforce what's already been ordered by the court, but also to potentially incarcerate somebody for violating one of the court's orders. It is a very strong sanction and does require the court to make certain findings of fact before they can hold a person in contempt. Now, you can file a motion for contempt if your spouse or ex has not paid court-ordered child support or alimony or anything else that's considered a support obligation. You cannot file a motion for contempt if your spouse was ordered to pay you lump sum money as part of equitable distribution in your case. Your final judgment should clearly spell out which monies are to go for support purposes and which money are to go towards equitable distribution purposes. The two most common ones are child support and alimony. If your spouse or ex has fallen behind on their child support obligations, you can file a motion for contempt and prove to the court that they're in what's called willful violation of the court's order. The difficult part of contempt, however, is that you have to be able to prove to the court that your spouse or ex has what's called the current ability to pay. So if you go into court and ask the court, I would like you to put my spouse in jail for non-payment of child support, the judge is going to say, okay, Mr. Simon, but how much money can you prove that this individual has the ability to pay to satisfy their support obligation? If you cannot prove through financial discovery that your spouse or ex has the ability to pay to what you're requesting the court, unfortunately, on a contempt basis, the court will have to deny your motion and simply issue an order slapping the other party on the wrist and ordering them to pay. You can also file a motion for contempt for willful violations of the court-ordered parenting plan or time-sharing schedule that you've entered into. I caution my clients on doing this too much because you don't want to have a reputation with the judge that you come to court every time there's a minor problem with your parenting plan. However, if there are major issues with pickups, drop-offs, communication, information sharing, or anything else that's adopted in your parenting plan, we can certainly file a motion for contempt and ask the court to address it. If you're experiencing any of these issues, or if you've been served with a motion for contempt and have a hearing set, give us a call today at 407-377-6399 to schedule your free consultation to go over all the issues in your case. Give us a call today, and we look forward to helping.